webinar on entity incorporation in India. My name's Beverly McLaughlin and I'm the Head of Marketing at Sannam S4. I'm based in London. I'd like to introduce our guest today. First up is Kapil Dua. He's our Group Chief Financial Officer and the Director of Financial Consulting, and he's based in Delhi. Kapil, welcome.
Thank you.
I'd also like to introduce you to Sneha Patwadan. Sneha is based in our Mumbai office and she's the Senior Manager responsible for Corporate Secretariat and Legal Services. Welcome, Sneha. Okay, listeners, without further ado, if you would like to ask a question as we go through our webinar, please use the messaging box in the bottom half of your screens. We're happy to answer any questions whilst we're online. If we can't answer them online, we'll obviously reply by email afterwards. Okay, so India is booming for foreign investors. However, setting up an entity in India is difficult. It's tricky to say the least. Whether you're an exporter who is currently looking to establish a more permanent presence in India, whether you're an educational institution looking to develop a more on-the-ground collaboration with your opposite number in India, whether it be a manufacturing base or an operations centre that you as a corporation are intending to set up in India, choosing the right entity from the outset is absolutely crucial. You need to consider factors such as your type of business, your objectives, your capacity, and also your ability to manage risk. Even so, the gains can be great. Kapil, first off, I'd like to ask you, can you share with us the different types of entity structuring that are available in India, and also what suits individual types of companies?
Absolutely. Thank you, Bev. Before even I start and go into the next slide, which is more about the setting up what kind of entities you can have in India, I would say this is the first most important step when you are thinking to enter into the Indian market, that what kind of business entity, what kind of legal presence that you should have in India, and think about it wisely, that what are the key elements which you should know when you are entering into the Indian market. And to start with, company is a very well known, the legal entity which is known all over the world. So I can define what are the types of company or companies you can have in India. To start with, you can have a one-person company in India, which is more recently after the New Companies Act, which came after, I would say, more than 50, 60 years. 2013, which is a new act, and that act has given this new phenomenon or a new structure option called one-person company. But I must say this is only applicable to the Indian residents. Individuals who are resident in India can open a one-person company. So it's not open to the foreign individuals or foreign companies. So I can straight away go to the second option, which is private company or a public company, which is similar to the private company in other part of the world. So difference between private company and public company is more towards how do you want to go and raise capital in your business. So if you would like to keep your shareholding and capital private to the individual, to the shareholders and if you want to go towards a public, like a public offering, listing on stock exchange, you would better go for the public listed company. And generally private foreign companies, when they enter into Indian market, they would start with the private companies. And then eventually when they go for the Indian listing or overseas listing of their Indian entities, they will go for the public companies. The next option also recently introduced by the 2013 Companies Act, which is called a small company. And it is a new form of entity. I can also combine it with a dormant company, which is another form. Both of these kinds of forms have number of exemptions given under the new Companies Act, that if you choose to have a small company or dormant company, you have a huge number of, I would say, exemption from annual compliances, regular monthly and quarterly compliances. The difference to have a small company or a dormant company, generally we have seen it, even though it's a new phenomenon or a new legal entity setup, dormant companies will be used or would be used by the companies or a business structure who would like to just hold an asset or IPR or some sort of other, the linkage where they would not like to make the Indian company operational. So this is just a vehicle as a dominant company to hold assets in that. The last in a company option, which is the foremost important, I would say Section 8 company, which is definitely, I would say, interesting or important for a number of our audience today, which are from the education or not-for-profit sector. So it is similar to having a non-for-profit in other parts of the world, where we call it Section 8 company, because this is a section of company law which defines how to set up this specific type of company. And it's more about towards the charitable education and a cause which is not for profit, and you would keep investing, reinvesting your profits and the money which you're earning into the same business without declaring any dividend or refunds to your shareholders. The next type of entity is limited liability partnership, which is very similar to LLPs in UK, in few other part of the world. And it's a hybrid between the partnership and a company. So you have limited liability towards the partners of any new or any kind of a business venture that they are entering into through their LLPs. Though it is not an very easy entrance structure for the foreign shareholders or a foreign investor, because they do require some sort of approval, which I'll explain in my next slide. And the other option to set up the entity is liaison office, branch office, project office. All these three are combined together to explain that they require the prior approval from Reserve Bank of India, which does take time. But it is more towards having a specific set of guidelines. If you're not thinking to earn profit in India or income from India, liaison office could be suited as a best option. If you're trading in some goods, branch office could be an option for you, but it's not a tax efficient option, which I'll discuss later. And of course, you can have a trust or a society, which is well-known phenomenon in terms of having few assets assigned to a trust, and trustees and beneficiaries are there, and a group of people can combine together to make a society. These are number of options to have entity in India. I would say when you're thinking to set up your presence or a legal entity in India, you do need to figure out what are the entry options, what kind of approvals you require. Should you come directly into Indian market as a subsidiary, or you tend to choose better jurisdiction, I would say tax neutral jurisdiction like Singapore, Jersey, Mauritius, and few other islands which are more tax neutral jurisdiction, and have your structuring accordingly. Save your capital gain taxes when you sell your profit making Indian business, and to choose about what kind of specific approval you need from either from Foreign Investment Promotion Board or central government. That really talk about how do you choose your best entity or a legal presence in India. So having said that, I must take you to the next slide, which I have tried. In that slide is how do I bifurcate or compare or talk more about key elements of few entities which I have in last 15 years. I have been advising foreign clients, which I have seen is more prevalent for the foreign investor, foreign individuals. They are more keen to set up these kinds of entities. So I'll just summarize. The slide is on. I can just summarize what I'm trying to explain here. So liaison office, branch or project office, profit-making company, Section 8 company, limited liability partnership, are just trying to differentiate it in terms of key elements, like which are the authority which you would require the approval, how much time it takes, what kind of approval you need. So for example, if you want to open up a liaison office, you do require Reserve Bank of India, which is central bank in India. You do require their prior approval. So it is a government approval route. It does take 6 to 9 months to set up a liaison office. And if you are an education sector, it can even take longer, because you do need when you forward your application to the Reserve Bank of India, they will go for further approval from the Ministry of Education or Ministry of Finance in order to get their stamp on it. So timeline is something which you really need to watch out for. in terms of incorporation procedure, in terms of the authority which will give you the benefit or which will give you the approvals. And similarly, I've also, if now we can go to the next slide and I can talk about that. I've given some sort of timeline in terms of I would say timeline, which is how much time, but at the same time, how much cost it takes you to set up that option, how easy it is to set up that option as an entity. So liaison office, I would still rank as a really strict option because you have strict guidelines and activities which you are allowed to do in a liaison office. Similarly, when you have a profit-making entity, you are fairly easy to do your business in India. Of course, it depends the kind of business which you are, whether that business required a specific approval from the central bank or from the Foreign Investment Promotion Board, or even it just does not allow you in India to do that business. For example, real estate trading is prohibited in India for a foreign investor. You can definitely come and build up townships and residential big projects up to some guidelines. But if you want to do real estate trading, like buying houses, selling houses, it's not allowed as a business. There are some sort of restrictions from a foreign direct investment perspective, which you need to think if you're in a retail sector, multi-brand retail trading, e-commerce, print and media, defense sector. These are all key sectors which India is growing and there are foreign investments coming. So you need to think about whether do you need approval? Are you coming into the automatic route of foreign direct investment into India, or you can just straightforward go ahead, incorporate the entity and do your compliances. And in the last point, I've also tried to give some sort of estimate that how much it will cost you to manage your entity from a compliance perspective, just excluding the accounting and payroll, because that depends upon your quantum or volume of the work. But generally, the annual compliances and quarterly and other tax and company law compliances, that's kind of expense you would be thinking for. So that summarizes the different kind of entity option you have there.
Okay, thank you, Kapil. That's really interesting. We've got our first question in, actually. It's from the university in Australia, and the question is, can you give some more insights into the Section 8 entity structuring and what the mechanics are of it?
Yes, absolutely. So for an education university, Section 8 company is the go for entity. I would even advise to go for both at the same time. I'll tell you why. So Section 8 company is a so they can definitely provide services like a Section 8 company, but they would not be able to take the profit or funds back to the home country because that's a prohibition under Section 8 company. Whereas you need a profit-making entity and work combined together as a structure in India and profit back. It's fairly difficult, I would say, to open a Section 8 company. It is time-consuming. It requires more cost. It requires more approvals from the central government. It takes around, I would say, even 9 months to set up a Section 8 non-profit company. You do need tax registration to be tax exempt. And they do ask for a number of documents. In fact, I was incorporating one entity for one of the big institute in America and US, and it took us more than 9 months because they asked for charter documents which was 150-year-old. So it does take time to get those documents, get it notarized in the foreign country. So it is a time-consuming process.
Okay, thank you. And what about royalties then and payments of fees and so forth if you're a foreign institution active in India? How do you actually get the money out?
Simple. As I said, you should better have two entities in India. One is profit making, the other is not for profit. So you can take your funds or royalties out from the profit making and have the profit making entity earning fees or management fees from the non-profit entity. So that's the route to the taking funds overseas.
Right. Okay. Thank you. Okay. So on to our next, onto the next issue, which we're often asked about, and that's about setting up a private limited company. Sneha, many questions are always coming in about this. Can you share some insight into how to set up a private limited company and what does it actually mean? Hello.
Thank you, Beth. Sure. In order to incorporate a private limited company in India, there are three prerequisites that you need to consider. One of them being the shareholders, the directors, and the capital, that is the company with which you would like to incorporate. To begin with, today, at this stage, you do not have a minimum paid-up capital requirement. So you can incorporate a company with a capital that you have in mind or your needs require. Moving on to directors, a private limited company in India requires two directors. One of them has to be a resident director. A resident director means a director who is resident in India for a period of 182 days in the previous calendar year. Now, this is a mandatory requirement. In order to be appointed as a director, you need a director identification number, which is called as the DIN. This DIN is allotted by the Ministry of Corporate Affairs. You have to make an online application to the ministry in order to obtain this DIN number. This application needs to be supported by documents such as your proof of identity, your address proof. These documents need to be notarized and apostilled in the country of the applicant. It's very important because Ministry of Corporate Affairs scrutinizes these documents, and only if they find them in order is the DIN number allotted to the applicant. You also need a digital signature certificate to go with the DIN application. The digital signature certificate is a signature which can be used by the applicant to file the form with the Ministry of Corporate Affairs. The documents required for DSC are very similar to the DIN, so we can simultaneously obtain a DIN and DSC for you. Moving on to the shareholders, a private company requires a minimum of 2 shareholders. Now, it could be 2 body corporates which are incorporated outside India, or 2 individuals, or a combination of a body corporate and individual, depending again upon the needs and requirements of the client. Moving on to funding, an Indian entity can be funded by various options. The most famous or being equity share capital. When you say equity share capital, what you mean is that you subscribe to the share capital of the company. There are various other options such as preference capital. This preference capital has a preference at the time of winding up of a company. You could also consider compulsory convertible debentures. This instrument at the time of issue is a debenture, but at a later stage gets converted into equity. You could also think of having funds in Indian company through income or revenue, but this could only be generated when the company actually starts operations. Loans and borrowings are restricted in India because in order to have loans and borrowings, you need to comply with or be eligible under the ECB guidelines, which are the external commercial borrowings. With this, we move on to the next stage in incorporation on the next slide as well, which is the name application. The name application is the name with which the company is incorporated in India. This name has to be approved by the Ministry of Corporate Affairs. A company can be incorporated with any name. For example, if the subsidiary or the holding company is XYZ Limited, you could have the Indian subsidiary be called as XYZ India Services Private Limited. At this stage, you also need the Memorandum and Articles of Association. These are the charter documents of the company. The Memorandum of Association lists down the objects or the purpose for which the company is incorporated. It's very important because a company cannot do any activities that are not listed in its memorandum. The Articles of Association, on the other hand, are the rules and regulations that govern the company. So it can have rules like when is a board meeting to be held, how it is to be held, when is a shareholders meeting to be held, how to give notices, so on and so forth. You also need to determine the registered office of the company. The registered office is the office wherein you receive all your communications. This can be in any state of India, be it Delhi, Mumbai, Chennai, Bangalore, again depending upon the need and the situation. At this stage, we also need a power of attorney. This power of attorney is only for the purpose of incorporation. And in order to get you all the documents and all the registrations that are required prior to incorporation. It expires once the company is incorporated. Once the company is incorporated, we move on to the next stage in the incorporation process. That is obtaining various licenses and registrations. We start with obtaining a PAN and TAN. PAN is the permanent account number, whereas TAN is the tax deduction number. These are mandatory registrations and are required even for opening a bank account of a company. We also assist you with holding of the first board meeting of the company, wherein you can determine who would you like to open your bank account with, what are the different registrations that you would like to have, who would be your auditors. We can also assist you and handhold you in this process. We also assist you with opening of a bank account. Now this is important because the shareholders or the subscribers who have decided to invest into India have to remit or send foreign exchange into this bank account. Since this is foreign exchange, you also need to comply with the RBI, that's the Reserve Bank of India guidelines and reportings, as well as the Foreign Exchange Management Act, which is again governs the foreign exchange in India. We also, at this stage, you need to determine what other registrations you would require, be it the shops and establishments, the sales tax, professional tax, provident fund, import-export, so on and so forth. So to sum it up, we not only help you incorporate the company in India, but also handhold you through registrations, licenses, bank account, and everything that you require to do business in India.
Okay,
over to you, Beth.
Thank you. I've got a question for you. Are all the registrations that you've mentioned, are they all mandatory?
Over to you, Beth.
Okay, I have a question for you, Sneha. Are all the registrations that you mention mandatory in India?
Not all the registrations are mandatory. The PAN and TAN, which are the income tax registrations, are mandatory. They are required by all the companies. But the other registrations, like the shops and establishment registration, depend upon where the registered office of a company is situated. If it's situated in Mumbai, in Bombay, you would need that registration. But if it's situated in Delhi, you may not need it. Similarly, the employee registrations, like the Provident Fund or ESIC, would again depend upon the number of employees that you have. So it depends upon a lot. Yes. Thank you.
Okay. Can we just go back to slide 6 now? Because another question has come in, and that is, what if we don't have a resident director on board currently? What happens in that scenario? What happens if we don't have a resident director on board currently? I think there's a delay on the line. Kapil, are you able to answer that question?
Absolutely. So I can very simply answer that. So if you don't have a resident director in India, we can definitely help you and assist you on that. We do provide a professional nominee director service, though that's one of the key element of our service. So one of our professional director will be on your board, and he will become like your eyes and ears for compliance perspective, and how do he will figure out what are the non-compliance in India, and he'll report back to the shareholders sitting overseas.
Okay, and there's another question here, which is, are 2 shareholders absolutely mandatory as well?
The answer is yes. You do need 2 mandatory shareholders, but of course it depends. You can definitely choose between whether 99% shareholding to one shareholder and 1% to the other shareholder. So that can be managed, but you do need two shareholders. One shareholder can be a nominee shareholder as well, and you can have an agreement with that the person is holding 1% shareholding on a nominee basis.
Okay, so the next part of that question I think you've answered, which is, so therefore you can have a wholly owned subsidiary in India. Is that correct?
Yes.
Okay, thank you. Thank you. There's another question coming in as well for you, Kapil, which is, why is an LLP restricted in India?
Well, that's a good question. So I wish I was the writer of law or making the act in India, but LLP is primarily restricted because it's a kind of a partnership. It's kind of a hybrid form of partnership. So that's why it is restricted, that Indian government do not want foreign shareholders to make partnerships in India without and having the unlimited liability, because if you allow them to do that, they can commit to number of liabilities in India and go back to their home country, and it will be difficult to trace them back. That was a key element if I go for the logic behind it. So that's why they are going slow. It's been 3-4 years when the law has come up, and it is still a restricted approval route. You do need approval from the central government of India.
Okay, but in other areas, Modi's government is making fast tracks in terms of making it easier to do business in India. And there's been a spate, in fact, of recent legislation and regulatory changes with specific implications for foreign investors. So, Kapil, could you share what the implications are of this latest spate of changes and regulatory legislation that's been coming about?
Absolutely, and personally speaking, I'm really happy to see all those changes. And from last 1 year, I'm following it on a daily basis, weekly basis. We're hearing all those changes. Just 1.5 years back, we come up with the New Companies Act. As I started saying something on that, so we are seeing number of changes. In fact, just 2 months back, World Bank did another survey after a Modi government of almost 10 months of Modi government, the new Prime Minister, and they come up that there are still, the ease of doing business in India. If India don't come up with those kinds of changes, we will be far behind again. So one of the recent change, I would say, earlier, as we have also talked about, there was a restriction, or I would say the minimum capital requirement in India. So any company, any foreign company would like to have a company in India, the minimum capital requirement was 100,000 Indian rupees, equivalent to almost say £1,000. And as per the recent changes, they have gone away with that. You can even open a company in India with with a $1 company. And that's a very, very welcome change. And they have also done number of changes. For example, there was third step, which was added in the Incorporation 1.5 years back, which was called commencement of business certificate. So recently in the new law, what they did, that every company who has opened up a new subsidiary in India, they are first supposed to send the minimum paid up capital requirement into India, and then only they will get the commencement of certificate, business of commencement certificate, and then they can start the work, which they have just gone away with it. So there is no need to, even after the certificate of incorporation of a company, there is no need for the third step to get another certificate called commencement of business. So they have totally removed that, which is very, very welcome change. In fact, 2 of my clients took 1 month to get that certificate, because it takes time to open the bank account. It takes time to get the money into India and then issue shares, and at the same time tell the ROC to issue that certificate. So that's one. I would say there are a number of changes in Section 8 company as well, which is good news for my audience who are from not-for-profit or education sector. What they have done, they have of course removed the minimum paid capital requirement. For example, they have also, there are a number of changes, but I would highlight few of them. For example, in India, you do need to have 4 board meetings in a year as per the company law. But for Section 8 companies, they have removed that restriction and just said that you just need 1 meeting of board of director in 6 months' time. They have also added an exemption where the minimum directorship, like in India, a director can sit on maximum 20 companies board. But what they have done, that if you are, as per the new changes, that if you are a director of a non-profit company or Section 8 company, it will not count in your list of 20. So you can have a best resource, best pool of person can also sit in your Section 8 company. So there are a number of welcome changes, I would say, which they have done, and it's primarily because it's to improve the ease of doing business. The four most important change, which I really liked it, though we have not started moving very fast on it, but for example, earlier it was three-step process. You have to first apply for a name of the company. The second step, you file the memorandum and article and all the documents related to that. The third step was commencement of business certificate. They have combined all the forms into one consolidated form. That means your hassle of going back to your home country for the notarization apostille from the Indian High Commission in your home country has just one step. You can combine all these three steps together, take a registration or documents approval from the Indian High Commission in your home country only once, and so be it. So that definitely reduces the time of incorporation, and also it will ease out the process of incorporating a company in India. However, the Indian authorities are training their employees, training the people who are actually doing it and implementing it, because it's just a 1.5 2 months old change, which has just recently passed. So it will take a few months for the authorities to know the new form well. Even we are also reading it at the same time. So, but I'm really happy to see that.
Okay. The authorities talk a lot about the new online process, or maybe it's the existing online process. Does the actual online process hasten the speed of which a company can be incorporated rather than the usual physical process? Is the online process in fact quicker?
Oh, absolutely, absolutely.
Yeah.
If I compare from 3 years back, it is definitely the online process which is making things easier. So 3 4 years back, I was supposed to personally go to the registrar or company office and submit the paper and ask them for the approval. Now I can submit everything online. I can ask them for the approval. If my case is stuck, if there are a number of queries raised again and again, then I may have to go make a personal visit to make him understand what is my business, why I'm filing this form. But I would say in more than 60-70% cases, I don't need to pay a personal visit to the registrar of companies, which is, so for example, equivalent to HMRC in UK.
Okay, thank you. I have another question that's come in. Can board meetings be held via teleconference, or do they need to be in person? That's a really good question.
Yes,
Yes.
it is. It is. Board meeting can be held on a video conference. I must use it again, video conference. It cannot be teleconference, and that video conference should be able to be recorded. And you have to keep the record for at least a year that the board meeting has held through video conference. And there are full set of guidelines. How do you conduct the board meeting? But in a summary form, yes, you can through video conference.
Okay, thank you. Another question that's come in. Are there any other regulations that we need to be aware of which may have a significant impact on my entry strategy?
Number of them. Let me
Yes,
try to say few. Let me try to say few of them. So to start with, I must say you really need to do your risk analysis, SWOT analysis. You have to think about it, what kind of entity structuring option you're choosing. Because it is really difficult in India to choose one option, spend 6 months. If you're, for example, if you're choosing a liaison office, it will take you 6 months to set it up. And if you suddenly realize, look, this such and such activity of yours is not permitted under the liaison office work, it will take you another 6 months to close it down. So you have almost lost 1 year of your business, which you could have earned profit or at least start the business in India. So first, foremost important, study well. People like us can help you, where you can think about it. What are the best option for the kind of work which you are looking for, the business objective? Second important thing, tax exposure. You really need to think about which entity is good for you from a tax perspective, whether you should do your tax neutral jurisdiction structuring. For example, if you're setting up a branch in India, it is 40% tax if you're a branch. On a company, it is 30%. But dividend or taking profit out from branch is easy. No, in terms of a company, you do need to pay dividend distribution tax, which is more than 17, 18%. So that's important to understand the tax of each and every entity, timeline. If you're setting up, if you want to set up and launch your office tomorrow in a month's time, liaison office is not a good option. It will take you 6 months even to take you there to set up your own office and do that. Documentation, notarization, apposal of your documents, that all required to be understood, that how much time it takes you to get your documentation from your home country. Mind you, each and every entity set up required your documentation to first signed by a notary lawyer in your home country and then certified by the Indian High Commission or Hague Convention Office in your home country of the applicant. So that's also something which is important. Issues regarding opening bank account, it does take, mind you, even if you are with the same banker, we work with all the big banks from HSBC to Citibank. It does take time to set up a bank in India because Indian bank will not entertain anything in relation to the KYC of the foreign bank. They will ask again all those documents, which may sometime in our experience have frustrated our clients, that I'm already authorized signatory on your bank in London. Why do I, or in US? Why do I have to submit my documents again? Because the Indian Central Bank is asking the Indian bank, which is an Indian branch of a foreign bank, to get that again. So there are a few issues which is definitely you can handle well. What we do, for example, it takes 3 months to set up a company. Then we ask the clients get prepared for all the banking documents in advance and just submit when we get the set of incorporation, and here you go. So you can save time by reworking and think more about it. And most important, again, as in the last registration, so documents, timelines in terms of getting your registrations in India, what kind of, as you already asked, whether do you need all kind of registrations? The answer is no, but you need to watch out what kind of registration you need. That's why you need local expertise, whether you need VAT, whether you need service tax, which are two different tax in India, similar to VAT in UK. We are coming up with a new indirect tax law called GST, goods and service tax, which is combined of 3 taxes: tax of goods, tax of services, tax of manufacturing. All 3 will be combined together under goods of services. I am really hopeful it will get passed in the monsoon session of the parliament, but let's all hope for the best.
Okay, Snehra, I've got another question in for you, and that is, what is the time frame for setting up a private limited company?
So to set up a private limited company, it could take anything between 10 to 12 weeks, when you can obtain, you can actually incorporate a company, have its registration in place, and get going.
Okay, so are you saying that by week 12, the company would, by all intents and purposes, be able to be up and running?
Correct.
Is that right? Excellent. Okay, so it's 10 to 12 weeks. Thank you. Okay, so just before we wrap up, just one last question to both of you. And that is, what other aspects should we keep in mind when deciding to set up a legal presence in India? What other areas should we consider? Is there anything that you haven't covered or anything that you would like to reiterate again to our listeners? Kapil, over to you.
Foremost important, do give us a call to start with. But to be honest, the most important is how do you define a best entity for you? Sometime, as I said, for the Education Institute, you do need to structure 2 entities in India because that's the objective. So entity setup and structuring entity is very important. And what I always tell my clients, and I must reiterate here, you do need to decide about your exit strategy. Entry strategy is definitely important, but you do need to think about how do you take your funds. Exit, I am not meaning that you close down your business and go away tomorrow. Exit strategy for me as a financial professional means that how do you take your profits? How do you take your monies out of India? Taking money out of India is not an easy process. So decide today that, okay, do you want to take money in the form of dividend, royalties? Do you want to take monies in the form of management fees charging to India, or you just want to sell your Indian company shares to a foreign shareholder and save from a capital gain tax perspective? So thumb rule, entry and exit strategy should be well thought through.
Okay, thank you. Sneha, is there anything that you'd like to add there?
I think he's covered it all.
Okay, that's great, including the sales pitch. Well done, Kapil.
Yeah.
Okay, thank you, listeners, for tuning in today. If you have any questions that you would like to put to us, please do continue to email us at either consult@sannams4.com or at kapil.dewar@sannams4.com. If you would like to take advantage of our financial services and our financial offerings, then please do get in touch. I think that's all from us today. Thank you very much again for listening, and until next time, goodbye for now. Bye.
Thank you very much.
Thank you.